Welcome to Small Practice Support information session number 66. In this recording, Rory O'Donnell talks to Justin Purcell about witnessing deeds and documents.
You're all very welcome to Small Practice Information Session 66. I'm here with Rory O'Donnell, and we're discussing witnessing of deeds and documents. So you're very welcome, Rory, and I'll stop the screen share. Just do a brief introduction of Rory. So Rory was admitted as a solicitor in April 1961. He founded Rory O'Donnell and Company in 1967, which became O'Donnell Sweeney in 1995, and is now Evershed Sutherland. He retired as a partner in 2009 and as a consultant in May 2021. He's been a member or consultant to the Conveyancing Committee since it was set up circa 46 years ago. Amazing. On the 12th of August 2021. So thank you very much, Rory, for joining us, and I'll hand it over to you.
Okay. Just before I start, I just mentioned that we'll be circulating a document which will contain all the notes that I'm going to give, and therefore there's no need for anyone to take notes of what I'm going to say. I'm going to start with the question of documents and the signing of documents. And we all know that you don't need a power of attorney to appoint an agent to sign in your behalf in every case. The most obvious example are solicitors signing contracts for sale, which we've all done as long as I've been in practice on behalf of clients. Now, not obviously for everyone, but it's fairly regular on that. Most solicitors have signed contracts, many contracts on behalf of clients, and there's no problem about it. And I've never known it to cause problems. For example, Section 51 of the 2009 Act, which replaced the old provisions we all knew from the Statute of Frauds, mentions that a written memorandum to bind somebody in the contract for sale of property may be signed by a lawfully authorized agent. It doesn't say even that it has to be appointed in writing. In DC's Act, a lease may be executed by the landlord or his lawfully authorized agent appointed in writing. Now, the next point I make is about something which I've actually never come across in practice. I mean, I've heard of it. I have had clients going when I was an apprentice, as we were then in the late 50s, and until 1961 when I qualified, you had people who couldn't sign their name even. I haven't really come across that for so many years but then you often found documents executed, such as wills, particularly where the person signed with the next, which is unheard of nowadays. The technical name for somebody signing on behalf of another is that the person signing is the amanuensis, which of course Latin word, which I only came across 20, 30 years ago for the first time, but and it's strange that the fact that the use of getting somebody else to sign on behalf of a person is recognized by various statutes. It's obviously best practice when you're dealing with legal documents to have signatures witnessed, and there are various statutory and non-statutory provisions setting out standards. Obviously, the first one I'm going to touch on is the Succession Act, and it provides what the provisions are in relation to wills. The deeds, it's the Conveyancing and Law Reform Act. The PRA have their own requirements, which not surprisingly follow the 2009 Act. The Law Society's Certificate of Title Act has its requirements, and obviously banks, when they're sending loan packs to solicitors to execute mortgages or to act for borrowers, have requirements as well regarding the witnessing. And these are something that we all have experience of. Now, the Succession Act, most people, when I have mentioned it to them, aren't aware that a person who's making will can actually get someone else to sign on their behalf as an amanuensis. I've never come across it in practice, but the actual wording of the Act permits this. The person must sign in the person's presence and direction. The second thing that a lot of people aren't aware is that the testator's signature doesn't have to be seen by the witnesses, it can be acknowledged. And that I'll give the quotation from the Succession Act in the paper that will be circulated. So you will see there that it is an acknowledgement is all you need. However, witnesses must sign their name as witnesses in the presence of the testator. So the testator can have signed, can then meet the witnesses, and if he acknowledges, or he or she acknowledges the signature, then the witnesses must actually witness the will in the presence of the testator and of each other. The 2009 Act, which I'll call the Land and Conveyancing Law Reform Act, a witness, again, it acknowledges the fact that a person can have the signing of the deed acknowledged to them. Now, unfortunately, it also does require that it be in the presence of the witness. So the acknowledgement must take place personally, in my opinion. I think many solicitors in practice, including myself, have had documents executed by someone whose signature you knew well, and you might have added your name as a witness, and it may even have been ultra careful enough to get it acknowledged to you as well by phone. But correctly speaking, if it's a deed, it must be witnessed in the presence of the person. The acknowledgement or the signature must be acknowledged in the presence of the witness. The certificate of title scheme it must be witnessed in the presence of the solicitor. So there's no escape there, it just must be complied with. Contracts for sale just says witnessed, and it clearly could be could be witnessed and acknowledged over the phone, and there's absolutely nothing wrong with that. Now, it does depend a bit on who it is and what you're signing and what's involved. There's a Law Society guidance on virtual execution of documents, which I've given the details of in the paper that'll be circulated, which talks about practice that I've never seen in connection with property, but it purports to say that the execution, it's appropriate for the execution of real estate documents. And for example, it talks about executed signature pages being emailed with authority to attach to the final version of a document. And personally, I wouldn't be very comfortable about that at all. And I don't believe that that recommendation was ever seen by the Conveyancing Committee, or certainly approved by it. And if it was some day that I wasn't there, which could well have happened. But the question of if you lay down guidelines in relation to it, I think no prudent solicitor would take a chance over the witnessing of the execution of mortgages, charges, or in particular the guarantees. And I say that having, you've all seen the history of what took place since the 2008 financial and property crash, and the lies that were told in court by people who swore, well, they didn't execute the mortgage, and if they did, well, it wasn't explained to them, and if it was explained to them, well, they didn't understand it and it didn't reflect what was agreed. So it just is not a safe area for solicitors to take any chances over. Powers of attorney, these are tricky, and they're particularly tricky in the way that they were used in relation to syndicates of people buying property for capital allowances and these various things that were a feature of what was going on from, I suppose, maybe before 2000, but particularly 2000 to 2008. And my general guidance in relation to those is to say that you must, if you're acting for a vendor, that you should get a proper precedent of a power of attorney to use, and the precedent's available. And there's no excuse for using some Mickey Mouse general one that actually is questionable. If you're a purchaser solicitor, you need to check it carefully. And the most important thing of all is to be aware of the requirement of the PRA. Now, I set out the wording of their requirement, which many of you may be aware of, which I think is totally improper. And I think the objective of the PRA having this is just to have the vendor solicitor and their insurer take full responsibility for the validity of the execution under the power of attorney. Now, the actual 1996 Powers of Attorney Act gives a protection to purchasers, which, and for some extraordinary reason, the conveyancing practice has never actually taken the precautions that are recommended and are provided for in the statutory provisions. I wrote a paper on it in conjunction with an academic shortly after the act, maybe the following year, and recommended what should be done. But then it just has slipped under the radar and nothing has ever been done about it. I think something needs to be done about it, because I think that the PRA practice is wrong and should be stopped. In relation to deeds of mortgage, charges, guarantees, and certificate of title, I don't think there's any doubt that physical presence is required to witness the witnessing of documents. So a question about deeds, in other words, if you're doing a deed and it's not going to be, you're not going to see the person, it's going to be acknowledged to you, I think that the attestation clause should actually reflect what the facts are. It probably isn't particularly important, because if you have to have it acknowledged to you physically, then you might as well just have the other ordinary attestation clause. But I do think that if they're not, they need to reflect what the actual deed says. Another thing just about people not being aware that you can actually execute a will and a deed by getting somebody else to sign on your behalf. You actually can do the same as in the granting of a power of attorney, which I wonder why, because I can't see that there was any great pressure for that. Lastly, I'm just touching on digital signatures, which are commonplace in corporate and commercial and cross-border work, and that their use has been accelerated, obviously, by the pandemic, and people would love to have them, in conveyancing. Now, my understanding of digital signatures, and I've looked into it, is that it relies on the person having one of these firms who set themselves up as guardians of the signatures, and the person signs on and gives all the necessary details, and they get a PIN number. Now, that's all very well, but if you're executing a property, who else might know the PIN number? For example, my wife knows the PIN number of my bank account, and I know the PIN number of hers. And I think we're probably not the only people that are like that. So what would be secure in relation to executing the transfer of property based on a digital signature? Personally, I think that one would want the witnessing is going to be the most important thing. Now, you can't use digital signatures for property yet, but it's only a matter of time. But when it does come in, I do hope that it comes in requiring that in the sale of property or any vital document like that, that they must be witnessed by a solicitor, because I think if they're witnessed by any Tom, Dick or Harry, what security would a person have, or would you be comfortable about it? And certainly, speaking for myself, I wouldn't. So I have just done a sort of whistle-top tour through my paper. I'm happy to deal with any questions that anyone would like to ask.
Yeah, thanks a lot, Rory. And I've just shared the document there with everyone, so if they would like to have a review of it quickly, but if anyone would like to ask us a question, I suppose now's the time. So I don't see any questions there at the moment, so maybe I'll just ask one myself. It's just in regard to witnesses for how important is it in the power of attorney situation for the doctor to sort of acquiesce in somebody speaking of sound of mind, let's say?
Well, that's a
Yeah.
very topical question. I mean, capacity is a big issue, and solicitors haven't always been as careful as they should be in relation to the issue of capacity. I think that if a solicitor has any doubt, you see, if it's a client you know for years, you're fairly okay, because you almost certainly know all the family circumstances and there can't be something hidden. But certainly I've been misled years ago where I was, let's say, a document, a voluntary deed was executed by a person, and I was told, well, the person who it was being transferred to was the only child. It turns out that wasn't true. And the deed was attacked later and was set aside quite properly. So there are times you can have a chat with somebody who is even somebody you've known for years, and you can have a chat about old times, let's say if you've known them for 20, 30, 40 years, and you can have a perfectly natural chat, and you wouldn't have any idea that this person actually couldn't remember what they did this morning or yesterday, and actually is really not fit. So it's a tricky area. If in doubt, if it's a very important thing, you're better to get the person examined by a consultant gerontologist, and a GP would probably may know the person very well, but actually would their judgment be any better than your own? I used to use, let's say, making wills for a person, let's say years ago, when I was working for a solicitor. When I first came to Dublin, he was town agent for a number of solicitors, and he used to get a call to send me to St. Vincent's Hospital or this hospital to make a will for somebody. So he ended up going into somebody you'd never met, you knew nothing about. And I took a view that I had to have some information about them beforehand. For example, how many children they had, on the basis that if they now didn't know how many children they had or what their names were, that their capacity was questionable. But this is just a very, very tricky area. And I'm not sure exactly where it's going with this pending assisted decision-making coming along the line. And I mean, I'm interested to see how that's going to work out.
So, Rory, there's a question there on the chat. I don't know whether you can see the chat there.
Hold on, I'm getting it. Yeah, okay. I see
to settle law.
I don't think it's settled law, but I think I'd be afraid that a judge
maybe, Rory, I'll just read the question in case somebody can't see it. So is it settled law that in the presence of does not include participation by video call, e.g. if a solicitor watch someone signing a document, can I later witness that signature in hard copy? Then what are the indicators of signature under duress? What that solicitors should look out for?
Well, taking the first part, I think in the presence of is almost certainly going to mean what it says and not by video or FaceTime or anything like that. That would be my view. Would it be a reasonable thing to do? Well, probably, if you know this person. The indicators of a signature under duress, I mean, duress is a very tricky area. It's as tricky as capacity, because if you have an elderly person who ends up going to live with one member of a family and ends up totally dependent on them, there's those situations have been abused many times. Now, of course, many thousands of times there was no abuse, and these are a very small percentage, but it is a possible area of abuse, and certainly solicitors need to be aware of it. And in those situations, I think if you're taking instructions, the instructions need to be taken in the presence of the person without anyone with them, which can sometimes cause problems.
So there's a question there.
Well, I think it is.
I'll just read out the question. Sorry, Rory, to interrupt. Is it wise to sign a contract for sale on behalf of a client? How is the solicitor protected if their client comes back arguing they were not aware of a special condition?
I think the answer is that if in doubt, don't do it. I mean, I would have signed contracts on many occasions. Almost always the person would have seen the contract and would have been discussed. And it would be somebody who I knew wouldn't behave like that. But yes, is it best practice? No, it's not. So it's the safest thing to do is to get the person to sign the contract.
What about having the licensee's signature as witnessed by a family member? Is that important?
Okay, execution of a license. It depends on the license, you see. A license for what? I mean, if it's the purchaser's signature to a deed or a lessee's signature to a deed, it being witnessed by a family member might be perfectly in order. The things to worry about are the person, a deed transferring property. It's the vendor's signature, the grantor's signature, or a person, let's say mortgaging a property. It's the mortgagor's signature that matters, or a guarantee, most particularly of all. I mean, they are the ones where the witnessing is crucial, and a family member is maybe fine for all sorts of things, but certainly not for significant deeds. You want to?
I'll read out that. So if anyone else wants to ask a question, we're just sort of moving into the last sort of 2 or 3 minutes of the call. So if you have a question, just stick it up there in the chat. So is it necessary to witness the signature of a person's who are witnessing a company seal?
Well, the person's countersigning the seal is part of the execution, and they are not witnesses as such. They're part of the execution of the document. And therefore, if there's a witness needed for it, then the witness has to be a separate person.
And I suppose in conclusion, Rory, what are the general sort of missteps that could be taken in the witnessing of documents? I know you've just given us a very in-depth analysis of it, but sort of just 5 things you should be very cognizant of when witnessing a document. The document witnessed.
I think that the important thing in relation to witnessing documents is to be careful, and the solicitor needs to put themselves first in these situations. There is an extra question which it's off topic, but in light of previous talk, am I satisfied that the bill currently in the Shannon the 2009 Act is sufficient to restore the pre-2009 position? And yes, I haven't seen what's in the Shannon, but I have the very unusually and on very strict conditions, the conveyancing committee team dealing with this, I think, which Paddy Sweetman has done fantastic work, as well as Peter Bland on behalf of the bar. Personally, I'm very satisfied with how far things have got and what I've seen. And
is this in relation to easements, is it?
Yes.
Yes. So yes, this was just an update as to what happened from our last information session. Do you want to just give a brief summary of that, if you don't mind, of the change that we were awaiting at that time?
Well, in effect, it gets rid of the problem area of, well, everyone knows what anyone who was there the last time would know that we're talking about getting rid of the requirement for registration. There's a question in by Pepe Santora.
Yeah. And then followed up by Michael, just in regards to witnessing of company seals.
Well, he's saying it's not necessarily under the Companies Act, but it may be that if it has to be witnessed as a result of some other requirements, then is a witness required? It depends on I think most people would prefer a deed that is transferring valuable property to be witnessed. But if it's not a requirement under the Companies Act, and would you take it, and have I taken ones which hadn't been witnessed? And the answer probably is yes, that I have. But would it be best practice to get them witnessed? I think it would.
And definitely, if you're to err on the side of caution, to have a witness would be better than not having a witness, surely.
Yes, absolutely. Yeah.
So just to be sure. So, Rory, thanks very much for joining us today. If there's a last question, we'll take it. But if not, we'll send out the document that you presented again later in the week with the recording. Thanks a million for joining us. Next week, we're joined by Oisín Geoghegan from the local enterprise office, who will give us a really good understanding of what's available to solicitors with regards to there's 32 offices nationwide. And there's supports available, mentoring, trading online voucher, depending, etc. So a more business side for solicitors and networking, etc. So if you want to join us next week to talk with Oisín, that would be great. It's open for registration. Rory, thanks a million for giving us your really in-depth analysis today, and thanks for taking the time out. Thanks everyone for joining us.
Okay.
So long. Bye.